It is my extreme pleasure to introduce our next speaker, Steve Schwinn, who is no stranger to delivering insightful and impactful presentations at Issues Briefing. We are thrilled to have him back here today. Steve brings a wealth of knowledge and experience in constitutional law and human rights as a professor and associate dean for research and faculty development at the University of Illinois, Chicago. He regularly writes for the American Bar Association's preview of the United States Supreme Court cases and is a frequent commentator on WTTW on issues related to constitutional law and human rights. Steve's past presentations have consistently left a lasting impression on all of us, as he has the unique ability to break down complex ideas into clear, actionable insights. I am sure all of us are anxious to hear what he has in store for us this morning as he shares his thoughts regarding constitutional limits on executive orders. Please join me in welcoming back Steve Schwinn.
Thank you, Barb, and thank you, everybody. What an honor it is to be with you today. This is really the highlight of my year to engage with you. And I'm just so honored and touched to be able to come back and talk about I can't say it without laughing, the limits of executive authority. Wow. What a topic. Yeah, what are they? Okay, well, I'll just go sit down now. Where to even begin? So I was writing notes for today's session and just kind of threw up my hands because I'm not even really sure what to talk about. And so I thought what we do is just kind of start with a little bit of audience participation, if that's okay with y'all. And just tell me, what are you worried about with limits of executive authority? The laws of our democracy. Yes. Okay. Okay. What are some things you're hearing about? Yeah. Okay. Yeah. So
where was that at?
how can an individual who
You want me to repeat
a month ago wasn't even affiliated with the government
Right.
wander into the treasury and get a hold of the payment system?
And without getting arrested.
And without getting arrested. Yes. Yes. Yes.
Because he's got billions in contracts.
You can do your question in the mic.
Okay, my question is a follow-up on the unelected person who has access to data, secret data, I mean, personal data, and who, what was my question? And who has a conflict of interest because he has billions of dollars in contracts with the government.
Yeah. Well, and not just contracts with the government, but you're in my information, right? Yeah.
Okay.
Yeah.
Changing the subject, not away from the limits, what is the possibility of the military following or not following orders given by non-military personnel?
Good. Good. Good.
I'll be over that way in a minute.
Yeah, and so what I think we would like to hear too is what is the most effective course of action we can take, you know, and just what are the different options for action?
Okay, good, good, good.
I'd like to piggyback on that as well. Which organizations could we contribute to that would increase the number of lawsuits being brought up against the present situation?
Okay.
We've been wishing that Congress would take action, and some of them are trying. Some of them are in fear of being primaried out of their jobs if they don't toe the executive line. What can we do about that? Is there a way that we can do something about primaries, that we can do something to encourage people to do the right thing?
Okay, good, good, good.
You have to use the microphone.
looking ahead down the path, if we had a president who chose not to understand that we have term limits and decided to run for, say, vice president, is there anything to stop that from happening?
Okay, good. I love the question.
I can't believe this is coming out of my mouth, but what are states' rights when it comes to almost anything that's announced by the executive branch?
Steve, I think we'll take one more question, otherwise you'll be here all day.
Fair enough. We may be here all day anyway.
Is there a limit to the number of executive orders any sitting president can write? Like a quantity?
We
Okay.
got pressure for one more.
What is our recourse if the president is not mentally competent?
Oh.
How is that determined? And what is the recourse of voters to remove them from office?
Okay, good, great question.
So I'm going to encourage everyone else to write your questions down on a card and bring them forward. And then if there's time after Steve does his remarks and answers our trillion of questions, he'll answer yours too.
That was extremely helpful to kind of know where your heads are and where my head is in thinking about the limits on executive authority. It's really frightening times, as your question suggests, and we're obviously thinking about these things, right? And so to talk about them, I think, is a good starting point. And then let's see if we can touch on as many different comments and questions that you came up with and leave some time for some more at the end. I really think most of this is just conversation, and I don't mean just conversation as minimal. As I'm going to say in a second, I think having conversations like this is really the most important thing we can do in a democracy. So let me tell you a couple of things that I've been thinking about. I'm curious to get your reactions on this. And I want to share with you what I think, as somebody who watched very carefully the first Trump administration and now the second Trump administration, what I think is going on here, why Trump is behaving this way, why Republicans in Congress seem to be falling in line. And pardon me for being political about this, but we're in political times, right? What I tell my students is when we think about issues of separation of powers, like congressional checks over the president or the power of the president or the role of the courts, issues that you all have touched upon, when you make your separation of powers commitments, make sure that they work both ways, right? And so maybe you like Trump and the Republican behavior, but if you do, are you going to like it if there's a Democrat in the White House and a Democrat in Congress, right? Or maybe you dislike it. Well, let's identify why you dislike it and then apply those principles to the Democrats in the White House and the Democrats in Congress and see if those principles hold. If they do, I think you're onto something in terms of your separation of powers commitments, is what I tell my students. What I think is going on in the Trump administration is something that I think of as constitutional negotiation, but a real crude form of constitutional negotiation. And let me tell you what I mean by this. Trump, from his very first action in office, the first go around, was involved in a policy kind of negotiation, right? This is a very transactional person and involved in a policy kind of negotiation through, you'll remember, the travel ban, right? Trump came into office promising to ban entry into the United States by Muslims, and he did. His first executive action was to ban entry into the United States by Muslims. Everybody knew that that was not going to hold up. That was crazy, but it caused mass confusion. It disrupted people's lives. It caused a lot of damage before the courts were able to catch up with him, but they did. And so he issued the first travel ban, caused mass chaos. The courts pulled him in, reined him in, and did their job checking the president, right? And so the president then went back to the drawing board and came up with a second version of the executive order, a somewhat more refined version, but still pretty sloppy, a pretty kind of meat hatchet approach to immigration. And it caused mass confusion again, and the courts held him up again, right? They did their job checking him. So he issued a third version of the travel ban, again, causing mass confusion, but somewhat more tailored, right? We're going to identify now particular countries that are predominantly Muslim that we think pose a security threat, but we're going to throw in Venezuela and North Korea so nobody thinks that this is really a Muslim travel ban. And the Supreme Court ended up holding it, right? Now, still a really extraordinary action, that third version of the travel ban, extraordinary. But if you look at that through a transactional lens, I think what the president was doing is a kind of policy negotiation with the courts, right? He was starting with a really blunt, crass, crude kind of opening offer that was extreme, right? Like I tell my wife, if we put our house on the market for $5 million, right, that's just a crazy opening offer. But it changes our frame of reference. It normalizes a particular discourse. It makes us think, well, maybe that's not so crazy, right? It's out there, but maybe it's not so crazy. And we kind of get reined in a little bit, reined in a little bit more. But ultimately, the policy that comes out is still very extreme. It's just not as extreme where we started, right? So maybe I get $1 million for my house. That's not bad. It's not 5 million, but if I start strong, I'll end up with something that is still way overpriced, right? And I think that's what the Trump administration was doing throughout the first term. I think now they're doing it with constitutionalism. And what I mean by that is they're making these kinds of opening offers and negotiations, not only in the policy realm, where we kind of expect politicians to behave that way, that's not totally off the wall, but now also in the constitutional realm, where the president can do some real damage. We saw this in the first Trump administration. If you remember, last summer, the Supreme Court granted near blanket immunity to a president, sitting or former, for illegal actions, right? And my read of that case is blanket immunity. In fact, my read of the case is the Supreme Court wrote a playbook for a president for engaging in illegal behavior and then being immunized. I mean, you just got to read the opinion. If you're the president, it's not hard to figure out how to engage in illegal behavior and immunize yourself. The Supreme Court gave him the playbook. Well, that was an extreme opinion by most accounts, but it wasn't as extreme as Trump's opening offer in the litigation. Trump was arguing for flat categorical immunity for any president, anytime, anywhere, under any circumstances, right? So again, a kind of extreme opening offer. The Supreme Court reins him in to some degree, but it's still a breathtaking opinion and a dramatic change from the status quo, a kind of constitutional negotiation. Now, we're seeing that in the second term. We're seeing that in a lot of different areas, but we're also seeing something kind of helping that effort with this sort of crude, crass negotiation, in my view. What we're seeing is a long-term trend by friends in the conservative legal movement to tee up some of these issues for the president. We've touched on some of them with the issues that you've raised. So if we watch carefully what the president is doing, they're taking a hatchet to the administrative state, right? Now, this ought to be deeply worrying to us all. I think we talk about it to some degree, but I think we ought to be talking about it a lot more because as it turns out, the administrative state does a lot of good things for us every single day. The Trump administration is taking a hatchet job to it, taking these extreme opening offer positions. Think about what it's done with the U.S. Agency for International Development, for example, USAID, shutting it down. Now, there's no way a president has the authority to do that. But even if he doesn't have the authority to do that, and he's reined in by the courts, he's going to have the authority to do something more dramatic than the status quo, right? I think what's been happening is there's this long-term 40 plus year, for maybe even longer, let's see, 40, yeah, maybe 40 plus year effort by friends in the conservative legal movement to promote what's called the Unitary executive theory, which would, in its strong version, allow the president basically to do whatever they wanted to with the administrative state, including unilaterally closing down an agency like USAID or the Department of Education, or firing people willy-nilly, or implementing a Schedule F, or any other thing that the president has been doing with the administrative state. We can talk a little bit more about that. And so I see this kind of confluence of a president who's willing to adopt this kind of crude constitutional negotiation propelled by this 40-year trend by current friends in the conservative legal movement that have teed up this sort of presidency and really invited this kind of behavior on the part of a president to achieve in the short-term policy aims But while they're doing it, they're fundamentally changing our separation of powers in seismic ways. I think about this as kind of tectonic plates shifting. This is really scary stuff. And it's scary for two reasons, maybe more, but let me share these with you. So one reason that I think it's scary, I had mentioned a second ago, when we make commitments about separation of powers, or we heard about states' rights, when we make commitments about what we sometimes call vertical separation of powers or federalism, the relationship between the states and the federal government, when we make those kinds of commitments, we really ought to be thinking about how our commitments are going to operate if the politics were not favorable to us, right? And what I worry about for the Republicans is they're setting up dynamics that when Democrats come back into power in the White House and Democrats come back into the power in Congress and in the Supreme Court, which they will, politics tend to swing in our country, and Democrats will come back. Now they've got a whole new set of tools, right, to do whatever they want. And I'm not sure Republicans are going to love that when Democrats start steamrolling the way that Trump has been steamrolling, or when a Democratic president behaves in illegal ways and can claim immunity based on the Trump ruling that Trump and his supporters set up. And so I worry deeply for the Republican Party for that reason. I worry for the Democrats too for that reason, for all of us, really. My bigger worry is that we fundamentally changed the separation of powers. In our system, you can actually make constitutional amendments outside of the amendment process specified in the Constitution, and we're seeing that unfold in real time right before our very eyes. We're seeing it through this kind of crude, crass constitutional negotiation that the administration is engaged in, propelled by this 40-plus year trend to tee up ideas like the unitary executive or to take aim at things like birthright citizenship. These are not new ideas. They've gone back in the think tanks 40-plus years. People have been working systematically to set up our system to make these kinds of changes. And I worry that they're now succeeding. They're succeeding in changing our separation of powers and our very Constitution outside of the ordinary amendment process through ordinary politics. That's deeply worrying to me, but it's also deeply exciting to me. And here's why. You might like what's going on with the Trump administration, and if you do, that's great. Go out and celebrate it because you're achieving victories, policy victories, constitutional victories, and more. Maybe you dislike it. If you dislike it, here's my message. They did this through ordinary politics, which means that we can too, right? We can too. And I mentioned a few minutes ago that I think conversations like this are the most important thing in many ways that we can do in politics today to influence change. And here's why. The more we talk about these things, the more we literally shape our Constitution. Our Constitution is amended through the amendment process, for sure. That's provided for in the Constitution, but it's rare. It's only happened 27 times in our history. We change the Constitution every single day with our understanding of it by having conversations like this and shaping our understanding of it. If we're talking to each other and to our friends, to our social networks, and getting out there and getting active in civil society groups like the League of Women Voters and having conversations exactly like we are today about what we think the separation of powers ought to look like, what checks there ought to be on the president, we literally are shaping that document. Now, there are other ways we can do it, right? But conversations like this, I think, are the starting point, and they're deeply important to me, which is why I'm just so deeply, deeply honored to be with you today to talk about these things. Now, there was a question, what else can we do, right? I think about this as kind of points of access in our democracy. In our constitutional system, there are a lot of ways that we can influence, and you know these as well as I do, but I'm just going to rattle them off because I think these are really important to think about. So points of access in our democracy. First, having conversations like this, right? Literally changing the frame, the sort of normalizing behavior about the way we think the Constitution ought to operate will have an impact on the Constitution. It just does because that's the way our system works. Another point of access in our democracy, obviously the right to vote. And I know that's what we're all about, right? That's what a democracy is, going to the ballot box, the right to vote. We heard Governor Quinn talk about petitioning and the right to petition. petition the government. And again, I know that's deeply important to this organization. It's deeply important to me. We have a right to do it, and that's a point of access in our democracy, to petition our government through organizations like the League of Women Voters and other civil society organizations, to petition our government for change. But let me tell you about some that aren't often on our radar screen. So one point of access that I feel really passionately about is our ability, get this, both as civil society, collective organizations, but also as individuals, to comment on what the administrative state is doing. As it turns out, when administrative agencies in the executive branch, when they engage in rulemaking processes, they have to go through what's called a notice and comment process. And maybe you'll be surprised to hear this, maybe you won't, but you and I as individuals can participate in that process. If we see something coming down the pike from the Environmental Protection Agency, or from the Department of Justice, or from the Civil Rights Division in Education, or from wherever, right? We can actually write in a comment, a formal comment, that they have to consider as part of their rulemaking process. By law, they have to consider it. We can do that as individuals. We can do it as a group. That point of access is increasingly important as the administrative state is increasingly important in our society. And as we're seeing the Trump administration systematically dismantle the administrative state, I would urge the League of Women Voters and all of us individually to keep an eye on what's going on with these administrative agencies. And if you don't like it, get involved. There's a mechanism for that. Here's another point of access that we as individual citizens don't often feel empowered to participate in, but let me assure you that we do. Litigation. And somebody had mentioned that a few minutes ago. How can we get involved in litigation? How can we support litigation? Let me give you some ideas. So there are dozens, maybe scores at this point, of lawsuits against what the Trump administration is doing. If that's your vibe, if that's where you're going, right, there are ways to participate in those lawsuits. What I tell my students, and when I talk to other groups, what I say is, look, all this stuff is public information. You can go to publicly available sources and read the pleadings, read the filings in these cases, and on the pleadings and on the filings are the names of the attorneys with their telephone numbers and emails. Contact them. Tell them you want to support them. Ask them what they can do. My son's he's going to be really embarrassed when I hear him, when he hears me talking about him today, but he's a sophomore at the University of Iowa. He had a project recently on the First Amendment in a journalism class. And he said, Dad, do you think it'd be okay if I just emailed such and such attorney at the Knight First Amendment Center in New York? And I'm like, yeah, they'd love to hear from you. And by the way, I'm friends with him, so I can hook you up. And he said, no, I don't want you to do that, but I just want to email him and have a conversation with him, which he did. And they scheduled it for like a half an hour. It went on for well over an hour by Zoom. This is a kid at the University of Iowa, a sophomore, who just wanted to know about the case, right? These are attorneys who want to hear from you. So one way to get involved is just contact the attorneys and ask how they can do it. If you don't know, today litigation is a political effort. It's not just rote law. So attorneys who are bringing these claims against the Trump administration, these didn't fall out of the sky. It wasn't the inspiration of a single attorney sort of twiddling their thumbs or gazing at their navel in their office by themselves. They've been working with coalitions of other attorneys, coalitions of civil society, coalitions of organizations like the ACLU or the Knight Center or the Brennan Center, all these different organizations that are doing this outstanding work, right? And state attorney generals, all the people who are interested, the League of Women Voters, all the people who are interested in these things, they're putting these coalitions together and they can use your help. They can use your help. Get in touch with them, ask them. League of Women Voters can file amicus briefs. This is something that you've done before, and you can get involved in litigation yourself. You know this as well as I do, right? And you know what kind of powerful voice you can have in litigation efforts. And so I would encourage you to think about litigation as a point of access in democracy, even if you're not a plaintiff in a case, even if you're not an attorney. there are ways to get involved, ways to promote litigation efforts, to think of this as kind of true our separation of powers, right? Keep our separation of powers in line. It doesn't go too far out of whack. We got to get involved in this effort. We got to be active in it. So points of access and democracy, very deeply important to me when I think about how we as citizens and how we as civil society can make change. But my bigger message is this, right? They've done this through ordinary politics. They've done this through the channels that I'm describing to you right now over the past 40 years. Now, they've done it with really good organization and with a whole lot of money, right? But if they've done it, we can do it too. That's what I urge you to think about. Having conversations like this is such a great place to start, but think about those points of access to democracy and think about how you as individuals and you as civil society can make changes. Now, I've sort of grouped my thinking about this into a couple of different areas, which I'm just going to kind of tick off and see. I don't know, maybe just by raise of hand, if you want to hear me say a little bit more about these and kind of give you an update about what's going on, or maybe you already know, and that's not a useful way to spend our time. I'm here for you. I want to do what serves your purposes. So I'm just going to tick off my areas, and maybe just by raise of hands, you can tell me if that's something you want to talk a little bit more about. Does that sound fair? Okay. So birthright citizenship. Is this something we want to talk about? Okay. Okay, good. I'd mentioned the Unitary executive and the Trump sort of hatchet job on the administrative state. Is that something we want to talk a little bit more about? Yeah. I'm seeing maybe even more hands. Okay. Sanctuary cities, something that's now hitting Chicago and Illinois. Yeah. Okay, good, good, good. And immigration enforcement. Immigration enforcement. Okay. I'm gonna use my discretion as person behind the microphone and say that we're gonna start with that last point and kind of move backwards. Does that sound okay with you? And so what I'm gonna do is just kind of describe to you what I've observed as somebody who's watching these things very carefully, kind of what's the state of play to the extent that we can even define it. And then I'd love to hear from you. And I'm gonna count on you keeping me on time. Is that okay? Good, 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 good. So immigration enforcement, there are a couple of things going on. We had heard a lot of bluster from the Trump administration early in the days that there was going to be this kind of, mass immigration enforcement, particularly in places like Chicago and states like Illinois that have identified themselves as sanctuary jurisdictions. As far as I know, we really haven't seen that. We've heard a lot of noise, and we do have some anecdotes about hyper aggressive immigration enforcement here and there, but we haven't really seen the kind of mass deportation effort that was promised by the Trump administration yet. Now, whether we will in the future, I just don't know. But here's the problem that the administration faces, and this goes a little bit to the unitary executive idea. By most counts, there are somewhere north of about 11 million unauthorized non-citizens in the United States. 11 million is a pretty big number for an agency, ICE, that has a budget to actually implement deportation proceedings against a very, very small fraction of that number. The way I approach this is that we've got immigration law on the books that defines about 11 million people in this country as unauthorized aliens that are deportable, right? And so under the law, they are deportable. And if you listen to Trump, what he's been saying is, well, in order to enforce the law, we have to deport all these 11 million aliens, and we're going to do it quickly right away, right? But here's the problem. Part of the law, too, is the amount of money that Congress has appropriated to the administration to actually engage in enforcement. Now, if Congress has appropriated only a small fraction of the amount of money that the agency needs to engage in enforcement, what Congress is telling the administration is, we want you to deport people, but only up to the amount of money that we've given you, right? Appropriations law, as it turns out, is law, right? It's passed both houses of Congress, signed by the president. That's every bit as much law as any other law, despite what we're hearing from some on the Republican side of the aisle in Congress these days, which again, I think is really dangerous for them to do this, but saying that appropriation law is, well, that's not real law. And so the president should just go out and enforce immigration and find money wherever they can. It doesn't work that way. So in any event, we haven't seen the kind of mass deportation effort yet that we expected. And I just wonder whether that's because there's a lack of resources that Congress granted the administration. But we are seeing some movement in other areas. So the Trump administration, for example, purported to shut down asylum proceedings and asylum claims for people incoming on the southern border. This is dangerous. It's dangerous for the individuals because they're subject to reprisal if they were deported back to their home country. That's the whole basis of their asylum claim. But it's dangerous for our democracy. It's dangerous because law says that anybody who sets foot in the United States, by whatever means, whether, I'll use air quotes here, legally or illegally, however they get here, they have a statutory right to claim asylum and to an asylum hearing before an asylum officer to determine whether they qualify for asylum. And in the meantime, they're here with authorization. As long as they filed their asylum claim, they're here legally and lawfully. Well, the Trump administration has basically snowplowed right through that idea, right? Now that's dangerous for our democracy because he's violating law, just right there in plain sight. There is a lawsuit to stop that, and I suspect that that lawsuit will win. But again, I think about this through the lens of crude constitutional negotiation. Trump has adopted an extreme constitutional view. I, as president, have unilateral authority to protect the national security interest, doing whatever I deem necessary, including shutting down asylum and violating US law in the course, right? The courts are likely to pull him back to some degree, but only to some degree. I expect that he still will achieve a pretty significant policy and constitutional victory in trying to shut down asylum at the southern border because he adopted this extreme opening position, right? Again, this kind of crude form of policy and constitutional negotiation. And so there's that. We're seeing Trump order Guantanamo Bay being reopened, right, for holding individuals. My own 2 cents is that just sounds wacky. Is it doable? Yeah, it's doable under law, but what a silly idea. Flights taking individuals back to their country of origin, right? Chartered flights taking people back. That's actually not a new thing. We've seen that before. Whatever we might think about it as a policy matter, it probably doesn't break a lot of new legal or constitutional ground. And so the immigration enforcement, I've actually been a little surprised, and maybe you've heard different things, but I've been a little surprised at how muted it's been, given all the kind of bluster that we heard from the administration in the early days. And I think that's a good thing, but I'm still holding my breath for more things to come. I've heard rumors, for example, about a second travel ban that would sort of revitalize what we saw in the first administration. He already knows he can do that because the Supreme Court told him so. And so I do expect that that'll happen at some point. You want to talk about sanctuary cities for a second? Okay, so sanctuary cities. We saw this in the Trump administration where the administration tried to clamp down on sanctuary cities. And I want to describe that process for you because I think it sheds light on what we're seeing today. In the first Trump administration, President Trump came out and said, we're defunding sanctuary cities. Any jurisdiction that identifies as a sanctuary jurisdiction will no longer be able to get federal funds, they said, right? Now, those of us that were watching that and understood constitutional law knew that that was undoable and crazy for a couple of reasons that I'll describe to you in a second. But what he was trying to do is threaten sanctuary cities, sow confusion, sow fear. We talked to somebody had mentioned earlier, sort of the fear that many people are feeling and therefore not resisting. Pretty clearly designed to do that as well. These orders to shut down federal funding to sanctuary jurisdictions were immediately halted in the courts for 2 reasons. One is that the president can't do that. The president doesn't have authority just to shut down federal spending unilaterally. If Congress has allocated money for such and such grants, for example, to the city of Chicago, the president has to issue those grants to the city of Chicago. That's the way things work. Congress tells the president how much money they have to spend, and the president goes out and spends it. They can't, what we call, impound that money by refusing to spend it for policy reasons. And if they do want to withhold the money to make a policy assessment of what's going on, they have to notify Congress. Well, the Trump administration did none of that. And so courts were quick to shut down these threats based on the separation of powers idea that the president just can't do this, right? There's a related idea that goes to the idea of sanctuary cities. Sanctuary cities it's not really a legal concept. What it is it simply means that the jurisdiction has decided that its officers and employees will decline to cooperate with federal enforcement officials in immigration deportation efforts. That's all it means. So as a UIC employee, I'm a state employee. What state law and city of Chicago law tells me is that I don't cooperate with ICE officials in immigration enforcement efforts. There's nothing in federal law that can require me to cooperate with ICE officials, and here's why. And this is kind of an interesting separation of powers dynamic that might be worth a beat here. So a long time ago, friends in the conservative legal movement pushed really hard for a doctrine that says the federal government cannot require states or state officials in their official capacities to comply with or cooperate with or enforce federal law. Federal government cannot require states, state officials, state employees to comply with or cooperate with the enforcement of federal law. They can't require. It's called the anti-commandeering principle. The court derived this from the 10th Amendment, although if you read the 10th Amendment, it says nothing like that. The court kind of calls this I call it a 10th Amendment-ish idea. Somebody had mentioned states' rights and how crazy it is we're talking about states' rights today. Yeah, this is states' rights on steroids, right? And so the conservative legal movement worked really hard to get that doctrine into place. And now they're seeing progressives use it to oppose federal immigration efforts. Isn't that interesting, right? And so again, I tell my students, look, be careful about your separation of powers commitments because they very well may come back to bite you when the politics change. And that's exactly what conservatives are seeing today. So jurisdictions like Chicago are saying, well, you can't force us to cooperate with federal immigration officials because of the anti-commandeering principle, by the way, that you yourself created, right? And the courts in the first Trump administration said, yeah, that's right. You can't do that. The Supreme Court never had a chance to hear the case, several cases, because Biden got elected and he shut down this kind of required cooperation regime that the first Trump administration established. But now the Trump administration is doing it again. DOJ has now sued the city of Chicago, the state of Illinois, and other sanctuary jurisdictions to force them to comply with federal immigration efforts. And it now has announced that it will withhold federal spending from sanctuary jurisdictions. Same old thing. Extreme opening offer in a constitutional and policy negotiation. We expect that the courts are going to rein them in to some degree. Even the Supreme Court, I expect, would rein them to some degree. But again, I remember the immunity decision, right? Sure, the Supreme Court reined in Trump's most extreme position, but he still got about 99% of what he wanted and fundamentally changed our separation of powers. I think that's a likely outcome in these sanctuary jurisdiction cases. And I worry quite a bit about that for all the reasons that we've talked about. And so I think that's something to keep an eye on. But currently, as a matter of law, there's no requirement that anybody in Chicago or Illinois cooperate with federal immigration officials. It's just not there, and they can't force us to. And so that really is the principle being litigated in those cases and in DOJ's threat to withhold federal money from sanctuary jurisdictions. Let me say a quick beat about Unitary Executive. I'm just kind of working backwards on my list. So I had mentioned that the conservative legal movement had long been pushing this idea of unitary executive. And you may have heard the phrase. I want to define it for you in constitutional law because this definition sheds maybe a different light on what the administration is doing. The unitary executive theory is a constitutional theory about the power of the president that says the president and the president alone has plenary authority over what goes on in the Article 2 branch, which includes everything in the administrative state. Okay, so a strong unitary executive theorist would say not only can the president hire and fire people, whoever they want, at will, irrespective of employment protections, irrespective of civil service protections, even potentially irrespective of non-discrimination protections, right? Moreover, that the president can order that ethics laws, we heard from Governor Quinn, ethics laws, ethics disclosure, conflicts of interest, things like that, won't apply or don't apply to portions of the executive branch. That the president can organize or reorganize the executive branch in whatever way that they want, right? And that the president could unilaterally shut down federal spending that Congress has authorized for the federal branch. The problem with this theory, as a matter of separation of powers, is that it's all wrong. These things aren't powers that the president has, they're powers that Congress has. And all you have to do is read the Constitution to see that. Congress has the power to create administrative agencies, organize the executive branch, vest administrative agencies with power, and fund administrative agencies. When they do that, then the president's job is to enforce the law pursuant to what Congress said. That's the way things work in our system. The president doesn't have this vast authority over the administrative state. As it turns out, Congress does. So where does this idea of unitary executive come from? Well, there was a case back in the 1980s called Morrison versus Olson that challenged the constitutionality of the Independent Counsel. The Independent Counsel Act came up in the Government and Ethics Act that was enacted in the wake of the Watergate scandal and created this office within the Department of Justice, an independent office, an independent prosecutor that could prosecute wrongdoing in the executive branch. And that's exactly what Morrison was doing, the independent prosecutor in Morrison versus Olson. The Olson is Ted Olson, by the way, who's a Supreme Court litigator and around in these legal circles. He's been around for a long, long time doing this kind of work, and he was doing it back then. Olson challenged the constitutionality of the idea of an independent prosecutor in the Department of Justice. And he challenged it on a number of different grounds, but one of the grounds was that if the president cannot unilaterally fire a prosecutor in the executive branch, then that's an impermissible encroachment on the president's power to execute the law, right? The president is the chief law enforcement officer, and therefore the president ought to be able to hire and fire any prosecutor at any time that they want to, because after all prosecutorial power derives from the president. You see, that's the idea. Well, in Morrison versus Olson in 1988, an 8-member court, one of the justices recused, flatly rejected that claim by a vote of 7-1. A vote of 7-1 in 1988 flatly rejected this idea of unitary executive. The one was Justice Scalia. He wrote a lengthy, oh, that requires a sip of coffee. He wrote a lengthy and scathing dissent laying out the unitary executive theory, saying that all prosecutorial power comes from the president, and therefore the president ought to be able to hire and fire any prosecutors they want anytime and have plenary control over the executive branch. Well, the conservative legal movement since 1988 has taken that dissent and turned it into a supermajority on the Supreme Court, the position of our sitting president, and the position of most of our members of Congress. That's where our politics are today. Now, that last point, I think, is especially salient. Most of our members of Congress, you might be saying, what? I mean, the unitary executive theory takes away from Congress's power, right? So why in the world wouldn't they be defending their power? Well, my fear is, and this goes to one of the points that somebody had made earlier, that people are putting parties above institutions these days in a way that our framers had never thought about, and undermining the separation of powers. What we're seeing in the Trump administration is take this movement toward the unitary executive from 1988, Scalia's sole dissent, to a majority on the Supreme Court today, super majority on the Supreme Court today, take it to dismantle USAID, threatened to dismantle the Department of Education, fire prosecutors who were involved in the January 6th investigations, fire or target individuals at the FBI who were even involved in investigating January 6th, right? Order a complete shutdown on federal spending that violates the president's executive orders, sanctuary cities, all the things that the president has been doing, attacking the administrative state and exerting this sort of outsized control over the administrative state, like breathtaking things that we just haven't seen before, are the unitary executive theory. Again, kind of overshooting, will get curtailed, but even the curtailment will amount to a fast change from the status quo.
Dave,
And-
can I interrupt one
Yeah,
second?
of course, of
Because we
course.
do have a question about the Unitarian state. Could he possibly stop elections or change how elections are run?
Well, he started to try to do that. Just a couple of thoughts on that. You might remember in the first Trump administration, after the election results came in, and even before the election results came in, he had ordered the Justice Department to engage in investigations of state elections that he called fraudulent. He can order the Department of Justice to do that. The problem is the elections weren't fraudulent, right? And so can the president, and do we expect the president to send out the Department of Justice to investigate midterm elections in a couple of years, for example? Yeah, that wouldn't surprise me at all. I think that'll happen. The other thing that he's done recently that more aligns with the unitary executive theory is he purported to fire Ellen Weintraub, the chair of the Federal Elections Commission. She's been on the Elections Commission for a long time, a couple of decades now, and she continues to be able to sit on the commission because a president has not nominated a replacement for her. And under commission rules, she's therefore allowed to retain her seat. Originally appointed by Bush, but has stayed in office and has been a vocal critic of much of the stuff that the Trump administration and some of the Republicans have done to curtail our voting rights. Now, why is this significant? So she purported to fire Ellen Weintraub. If you've been following the Federal Elections Commission, they're basically at a deadlock anyway. And so they're not doing any enforcement of federal election law or federal campaign finance law. But this is a real, this move is a particularly kind of aggressive move against the FEC. And Weintraub has come back and said, I'm not going to have anything of it. I'm staying in my job. I'm going to continue to draw my paycheck. You know, they're going to have to pull me out. Now, the problem is they will pull her out at some point and she'll sue. And then we'll get yet another test of this unitary executive. But we've seen the Trump administration fire 17 inspectors general from different agencies, some of which Trump put in the office in his first term, fire attorneys at the Department of Justice, fire basically the entire USAID, right? Start to think about restructuring the Department of Education and firing staff at Department of Ed. And then this whole buyout program, right? The whole buyout program where Elon Musk says you've got a fork in the road. Why don't you make a decision? Do you want to go on leave and get paid until August? Or do you want to stay in your job and potentially lose it? That's been held up in the courts already. And the reason why is because we're currently operating on a continuing resolution for government funding that expires in the middle of March. The government can't commit beyond the middle of March to make those kinds of payments. And so the federal courts so far have held up that offer to federal employees. But these are all manifestations of the unitary executive, and this could have a dramatic impact on voting rights in a lot of different ways. Yeah. So just one quick beat on birthright citizenship. So we might think, well, okay, birthright citizenship, that's in the 14th Amendment. Like you can't change that, right? Well, you can try to change it. So what the Trump administration has done is issued an executive order purporting to pull back on birthright citizenship. There are two parts of the clause that we got to pay attention to. One is born in the United States, right? The other is subject to the jurisdiction of the United States. Now, there's no doubt that individuals who are born in the United States are born in the United States. They're born to unauthorized non-citizens, but they're born here, right? And so the tack that the Trump administration has taken is to say that individuals who are born to non-citizens who are here without authorization aren't subject to the jurisdiction of the United States. And the theory goes like this. They owe allegiance to their home country, right? Is what they're saying. And because they owe allegiance to their home country, they're not subject to the jurisdiction of the United States. Now, my guess is always that if an unauthorized alien engages in illegal behavior, I think everybody's going to agree they're subject to the jurisdiction of the United States. Like, this strikes me as kind of crazy. But here's the thing. We've seen the Supreme Court go with craziness before, and I think we could see it go with craziness again. It wouldn't surprise me at all if the Supreme Court were to adopt the Trump administration's view on birthright citizenship. Again, a dramatic overreach on the part of the president, the court pulling them back a little bit, but they've still achieved a huge change in separation of powers and underlying public policy. So that's my list. Let's hear more about what you all have to say.
Well, I hope you brought your jammies because we have tons of questions. One question that's come up is the concern over Elon Musk. I mean, do we not have a right to privacy? And how can this unauthorized person, unvetted person, have access to all this information?
Yeah, it's a great question and a disturbing one. Luckily, it's an easy one legally. They can't. And so for the president to allow them to is yet again an exercise of the unitary executive authority. The problem that they're running into here in litigation is that Musk's access to the payment system violates all kinds of privacy laws. And so these litigation now is actually holding up Elon Musk's access to the payment system. Trump administration's position on this is that they have only read-only access. I don't know what that means. I mean, as far as I know, you can read my social security number and date of birth as well as you can change it, right? Or my bank account or whatever. But the privacy laws are holding them up in doing this. But again, another manifestation of this unitary executive theory.
We've had several questions about people who are expressing concern that we all have of what happens if these rulings come down and Trump refuses to accept them. How is those rulings enforced?
Yeah. Some of my colleagues say, that we haven't yet experienced a breakdown in democracy. I'm not so sure about that, but they say that the determining factor when we will experience a breakdown in democracy is when the Trump administration flatly ignores the courts. I don't expect them to flatly ignore the court. I expect them to do what we're seeing in the funding restriction litigation right now. So if you've been following this, the Trump administration halted all federal spending that was inconsistent with its executive orders, which the administration more or less read as halting all federal spending. Now, the courts immediately stopped that because, again, the president doesn't have authority to impound federal law. That violates the separation of powers and the Impound Control Act. That's a widely accepted principle. And so the courts halted the president's halt on federal spending. But the problem was the individual agencies were still halting federal spending. They were still halting it, right? And so that litigation is ongoing. The plaintiffs in a case out in California filed a brief just yesterday making this argument that the administration is not complying with the court order to halt their pause. And we got to do something more aggressive. We'll see what the courts do and how the Trump administration reacts. But my point is that I think what's going to happen here is that the Trump administration is unlikely to flatly ignore court rulings. I think what it's more likely to do is half-heartedly comply so that they can say they're complying, right, even to the court, but actually not comply. The other thing that we're seeing in this litigation, it kind of gets into the weeds, but there's an argument by some of the administrative agencies that have continued the pause that the court orders don't apply to executive orders for a variety of technical constitutional reasons. It's just a crazy argument But the point is that if they can continue to launch these crazy arguments, eventually one of them is going to stick, right, with somebody. Even if it doesn't, they're doing tremendous damage in the meantime. And so, government contractors, anybody who benefits from government spending, I'll tell you, as a faculty member at UIC, we receive a lot of federal spending through NIH, CDC, as many institutions do. It's really scary times, really scary times.
Shifting gears a little bit, we've had a couple of questions about the seemingly attack on political enemies. And is there any thought or thinking that there might be an implementation of the Alien Seditions Act?
Well, yeah, that is a worry. I'm gonna expand on that a little bit.
I was hoping.
So, I mentioned earlier that Congress, as a matter of separation of powers, Congress enacts law, the president enforces it, right? But here's the thing. Congress over time has given the president tremendous emergency power as a matter of statutory law that allows the president lawfully, in compliance with federal law, to do breathtaking things. So, for example, the president's most recent round of tariff threats, he has cited as authority for that one of these emergency acts. This particular emergency act has never been used for tariffs before, but he cited as authority for that action an emergency act that was enacted by Congress that he says authorizes him to do that. He's citing different authority in immigration enforcement in unusual and creative ways. Some of it is emergency authority. I would count the Alien and Sedition Act as kind of part and parcel of this larger picture of Congress delegating authority to the president to do extraordinary things in the name of a national emergency. And we're seeing this president accept that invitation and go ahead and do it. Now, the problem with this is that when a president cites national security or national emergency, the courts tend to defer to the president, especially if the president has statutory authorization to take the action. Again, think back to the first Trump administration travel ban, where he cited, this wasn't emergency authority, but something like national security interest in implementing the travel ban. And the courts put a thumb on the scale in favor of the president because of that. Well, this was a federal statute. And so a lot of these things, we look to Trump and say, wow, he's really overreaching. Yeah, in some ways, but he's also citing authority that Congress has granted him. In the first Trump administration, an outfit that I'm sure you know about, it's called the Brennan Center at New York University, issued a comprehensive report on all the statutory authorities that the president has to engage in emergency action. And if you're interested in this, I'd encourage you to Google that and check out the report. It really is quite breathtaking. What it says to me as a small d Democrat is that, if we don't like some of the stuff that's going on, maybe some of this has to do with Congress too, right? And somebody had asked earlier, do we have the power to fire people in Congress who aren't doing their job? Yeah, we do in a couple of years. And I hope that we do, so that Congress can reconsider some of these emergency authorities, among other things.
A call to action. Several questions now go back to a question that was related to at the beginning, is the length of the possible Trump presidency. Wonder if he doesn't leave office. Wonder if he changes the possibility of election. Could he become vice president in 4 years and then eventually become president again? All these questions are related to his possible future. Can you foresee?
I mean, if we've learned one thing from Trump, it's that you can't really predict anything. The 22nd Amendment prohibits a third-term presidency. 2 terms is what it says. It doesn't specifically say 2 consecutive terms, but we've always understood it that way. The Trump administration and supporters have adopted the theory that the 22nd Amendment was enacted in reaction to Franklin Delano Roosevelt's multiple consecutive terms, and therefore we ought to understand it as banning only consecutive terms, right? And so the theory behind this is, yeah, he can serve a third term. It would only be a second consecutive term, or he could be vice president and then come back to the presidency in a kind of Putin way in the next cycle, right? And they wouldn't be consecutive terms. Yeah, scary, scary stuff. But these theories are floated out there. And again, you know, the theories are floated out there in public discourse, which is why having conversations like this is so important, right? We can talk about these things too. If you don't like that theory, write a letter to your editor and say how wacky it is, or talk to your friends about it and get them to do that, or organize a civil society and write a letter together, or talk to your representatives, talk to your elected officials about that kind of thing, and make this constitutional change yourself, because you know what? They're making it themselves by having these conversations and normalizing this idea that the 22nd Amendment would not bar a third Trump term.
And then we thank you, Steve. I think your time is up, and it's a good way to leave it, as we can do something.
We could do it.